SwayamPrabha. Digital India. Educated India.
Students, this is my 11th lecture. My name is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU, and today's topic of discussion is right to fair trial as a human right. So, in this lecture, I am going to discuss principles, feature of fair trial. As you might be knowing that fair trial is important component of justice delivery system. In this lecture, I would like to highlight those important component of fair trial which must be followed by the court, particularly criminal court. So, with the help of this slide, I would like to highlight some important international instruments, and then after I will try to give you some example and this right to fair trial. So, let us see how right to fair trial is considered as human right. Students, you all might be knowing that United Nations General Assembly on 10 December 1948 adopted a resolution. On 10 December 1948, United Nations General Assembly achieved a big achievement, you all might be knowing, that is Universal Declaration of Human Right, UDHR. So, Universal Declaration of Human Rights 1948, Article 10 of UDHR, I have highlighted that provision in this slide, that Article 10 of UDHR talks about right to fair trial, that every human being is entitled to be tried by competent authority fairly. So, right to fair trial is human right, and every human being against whom criminal charges are initiated, that person is entitled to be tried by competent authority fairly, in fair manner. So, what things are necessary? What things are required for fair trial? As you all might be aware about presumption of innocence, there is basic principle of criminal law that presumption of innocence. Every person is presumed innocent unless his guilt is proved before the court of law. So, this is presumption, and even this, you see, presumption of innocence is also human right provided in Article 11 of UDHR. So, with the help of these two important provisions, Article 10 and Article 11 of UDHR, we will try to understand the concept of fair trial in criminal justice system. So, as I told you that right to fair trial, that is human right provided in Article 10 of UDHR. Why this right is provided as human right, right to fair trial? Because of that presumption which is recognized as right, human right under Article 11 of UDHR, that is presumption of innocence. Every authority, every court, be it civil or criminal, every and particularly criminal courts are bound to presume accused who has come before the court innocent unless his guilt is proved before the court. So, because of that presumption, every person has right to fair trial. Every person against whom charges are levelled, that person is entitled to be tried by competent court fairly. So, fair trial is human right, and this right to fair trial is essential component of right to life and personal liberty. As we all know that there is a proverb, there is basic principle of justice administration, justice, that justice not only be done but it seems to be done. And second is justice delayed is justice denied. So, justice not only be done by the court but it seemed to be done, meaning thereby even all the requirement which can fulfill the basic requirement of fair trial must be followed by competent court, and must be all the basic requirement which accused can claim against the state must be provided to the accused by the state. So, now let us understand that what are the principal feature of fair trial. You see, a criminal court which is going to try a criminal case and accused is poor. So, criminal court has to provide counsel to that accused free of cost, because accused is poor, accused who against whom charges, criminal charges is levelled, he is not in position to engage his counsel on account of poverty. So, it is legal obligation of state to provide counsel to that poor accused. So, how this thing can be linked? You just see in the second slide I have highlighted certain important component of fair trial. As you can see, right to know charges and ground of accusation. So, every accused who has been arrested by the police officer has right to know the ground of arrest, ground of charges, on what ground he has been arrested and what are the charges against him. Authority is bound to disclose the ground of charges, authority is bound to give ground on which authority has arrested him. So, right to know the ground of arrest, right to know the allegation, that is basic right, that is human right, that thing must be provided to the accused. Why? This is a basic right to know the ground of arrest. Unless and until an accused who has been arrested by a police officer is not informed the ground of arrest, he cannot defend himself before the court effectively. And right to defend himself, as you all might be knowing, that is fundamental right. So, every person has right to defend himself, every person has right to be treated innocent unless his guilt is proved before the court of law. So, that person is entitled to know the ground of arrest. This is, you see, this fair trial starts from this point, and this is also important requirement for fair trial. You see, at the time of trial, if accused has raised any objection before the criminal court that accused was not informed the ground of arrest, without informing the ground of arrest, accused has produced before this court. So, at least accused must be informed that on what ground, on what charges he has been arrested by the arresting officer, and court is going to prosecute him. So, that is why this is very essential requirement which authority is bound to, arresting officer is bound to disclose ground of arrest. Second important provision, statutory provision, which you can see in the in the CRPC, in the Code of Criminal Procedure 1973, Section 207 CRPC 1973 talks about right to get copy of FIR and list of prosecution witness. You just can see right to get copy of FIR, section 207 CRPC, and list of prosecution witness. You see, it is very essential to provide a copy of FIR to the accused, so that accused may get entire information on what ground he has been arrested by the police, what are the charges against him. So, because of that reason, every accused has right to get a copy of FIR free of cost. Second important thing is that section 207 CRPC has imposed obligation upon the magistrate, that magistrate, before initiating any judicial proceeding against accused, must ensure that whether accused has been provided a copy of FIR free of cost. Second, whether accused has been provided list of prosecution witness free of cost. All the relevant documents on which criminal court is going to prosecute an accused must be provided to the accused. So, are you getting my point? You see, Criminal Procedure Code has imposed obligation upon criminal court to provide all the relevant document to the accused against whom criminal court is going to initiate criminal proceeding. Without providing a copy of FIR to the accused, list of prosecution witness to the accused, charge sheet section 173 CRPC to the accused, that trial court will not start the trial. So, the purpose behind providing all these relevant document to the accused is to pay due respect to human right, because right to fair trial is a human right, and no trial would be treated as fair trial unless accused is provided all these relevant documents free of cost. So, you need to remember section 207 CRPC. So, you can refer section 207 CRPC that without compliance of section 207 CRPC, criminal court cannot start any trial. Now, come to another aspect of fair trial. I am talking about principal feature of fair trial. So, it would be pertinent to mention two important provision of Criminal Procedure Code, section 303 CRPC and 304 CRPC. You all might be knowing that legal representation is fundamental right as well as legal right. Every accused is entitled to be represented by his counsel. Every accused has right to get legal assistance of his own choice. No case shall be decided by the court without providing counsel to the accused. This is provided under Article 22 of the Indian Constitution. Article 22 Indian Constitution, as you all might be knowing, Article 22 says that every accused shall have right to consult from his counsel, to take legal advice from his counsel of his own choice. State will not compel him to take legal assistance from an advocate, from a counsel. So, it is a fundamental right of each and every citizen of this country to have legal counsel of his own choice. So, Article 22 makes it clear that even accused against whom charges are initiated, criminal charges are levelled, that accused is also entitled to get legal assistance from counsel, from his advocate. So, that is briefly you can say right to legal aid and right to free legal aid. So, right to legal aid is fundamental right provided in Article 22. Every person has right to get legal aid, legal assistance from his counsel from his advocate. So, without legal representation, neither civil case nor criminal case can be decided by the court. So, you must understand that this legal representation, right to legal representation, that is fundamental right, and this fundamental right is available to civil cases as well as criminal case. So, in civil case also, a person is entitled to get legal assistance of his own choice. He can counsel, he can take advice from his or her advocate. Section 303 CRPC and Article 22, you can see this, I have mentioned these provisions, Section 303 CRPC, Article 22. So, this is a right to legal aid, this is fundamental right because it is provided in Article 22 as well as statutory right, it is provided in Section 303 CRPC. So, without representation, criminal court cannot decide the case. So, that is why it is the duty of criminal court to ensure that whether accused has consulted from his counsel or not. So, accused may be asked to take legal assistance from advocate, from counsel. And another important fundamental right, that is right to free legal aid, as you all might be aware about Section 304 CRPC. Section 304 CRPC says that where accused is poor, unable to engage his counsel in court of law, is unable to pay court fee, that accused must be provided counsel free of cost. So, Section 304 makes it clear that all the accused shall have right to get free legal aid free of cost. So, it is constitutional obligation of a state to provide free legal aid to the accused, and because of that presumption, every person is innocent unless his guilt is proved before the court of. And Article 21 of the Indian Constitution, which talks about right to life and personal liberty, every person has right to live with human dignity, Article 21. So, Supreme Court has recognized a right to free legal aid as essential component of right to life or personal liberty. If a poor accused who is deprived from this precious right, it would be violation of his fundamental right guaranteed under Article 21 of the Indian Constitution. So, we will try to understand this in light of judicial pronouncement. Firstly, you see, right to know the ground of arrest, accusation. Now, we will try to understand that what are the statutory provision under which statute provision regarding fair trial is given. So, as you all are aware about fair trial, CRPC, the Code of Criminal Procedure, and Constitution. You will have to refer these two important acts, constitutional law and CRPC. So, you can see section 2, this is my fourth slide, where I have highlighted statutory provision pertaining to fair trial. Section 211 CRPC talks about framing of charges. Criminal court has to frame charges. So, framing of charges and ground of arrest. If you see these two provisions, arresting officer is obliged to disclose the ground of arrest. Similarly, criminal court, which is going to prosecute and convict an offender, is under obligation to frame the charges in the presence of the accused. The purpose of framing of charges is to give information about allegation, to give information to the accused about crime which he has committed. So, the purpose of framing of charges is just to provide an opportunity to the accused so that he may become aware about the charges, about the allegation on which criminal court is going to prosecute him. Section 209 CRPC we have already seen in previous slide. Now, right to have counsel of his own choice, Article 22, 303 CRPC, I have already highlighted. No one can be punished without unheard. So, this is the purpose of section 303. Right, no person can be punished without unheard. This is principle of natural justice, RD alteram partem. No person should be punished. So, opportunity, without giving opportunity of hearing to accused, criminal court cannot take decision against him. So, it would be against the spirit of natural justice. It would be against the principle of natural justice, rule of fair hearing. So, rule of fair hearing also requires that person accused must be informed the ground of arrest, on what ground court is going to, so that he can defend himself, so that opportunity may be given to that accused, and accused may discard the allegation, may reject the allegation which prosecution has made against him. So, right to know ground of accusation is essential component of. Now, come to this right to free legal aid. How this right to free legal aid is essential component of. You see, supreme law of the land, Constitution itself talks about right to free legal aid. A person who is not in position to access to justice on account of poverty, he is poor. So, poverty would not be a barrier to get justice from the court. So, Supreme Court in 1978 categorically held that right to free legal aid is essential component of right to life or personal liberty. This right to life would be meaningless for those people who are underprivileged, who are poor, who cannot afford court fee, who are not in position to engage their advocate counsel in the court of law due to poverty. So, that right to life would be meaningless. So, you see how Supreme Court connected this right to life with free legal aid. Supreme Court said that where an accused who is poor and that poor accused is languishing in jail due to poverty, no advocate is willing to fight his case because he is poor. He cannot pay fee to the advocate. So, in that situation, it would be injustice on the part of the government, and government being parent patria, it ultimately government has taken responsibility to protect life and limb of its citizen, and accused who himself has breached the law, and accused who himself is a criminal, but because of that presumption of innocence, every person must be presumed innocent unless his guilt is proved before the court of law. Because of that concept, accused is entitled to get justice from the court, and particularly if accused is poor, then responsibility lies in the state. State will have to provide counsel to that poor advocate or to poor accused free of cost. So, you see, this right to free legal aid was recognized as essential component of right to life and personal liberty in 1978. The name of case is M.H. Hoscott versus Union of India, AIR 1978 Supreme Court. Another important case on this point is Khatri versus State of Bihar, AIR 1980 Supreme. You see, I have also highlighted this case in my slide, Khatri versus State of Bihar, AIR 1979. This case is popularly known as Bhagalpur blinded case. Bhagalpur blinded prisoner case. This case is popularly known as Bhagalpur blinded prisoner case. I just want to highlight the facts of this case so that you all may be in position to understand the entire concept of fair trial. So, without having idea about this case, M.H. Hoscott case and Khatri case, you won't be in position to understand the concept of fair trial. So, you see what happened in Khatri case, Khatri versus State of Bihar. Police officers, they had arrested several accused in commission of any crime, but when they were interrogating the case, in Khatri case, they tried to obtain confessional statement. They were trying to get confessional statement from the accused, due to which they assaulted the prisoner, and many prisoners, about 24, you see there were about 15 prisoners out of 24, they lost their eyes and they were poor. They were not in position to engage their counsel in the court of law. When accused were produced before judicial magistrate, even judicial magistrate did not provide legal aid to those accused who were poor. So, matter was ultimately brought into the notice of Supreme Court that it is a case of negligence, it is a case of custodial violence, and police personnel who were involved in that custodial violence must be prosecuted and convicted for wrongful confinement and assault. So, Supreme Court considered the gravity of that case, and considering the gravity of that matter, Supreme Court intervened in this case that judicial magistrate was under obligation to provide free legal aid to those accused who had been produced before the judicial magistrate. Though accused, they did not make any application to the magistrate, they were ignorant about their rights, they were illiterate, they were not so educated, and they were poor as well. So, because of that reason, accused, they did not make an application to the magistrate for legal aid, free legal aid. So, that plea was not accepted by Supreme Court. Supreme Court said that accused were poor and they were not in position to engage their counsel due to poverty, as well as they were ignorant about their rights, they were not educated people. So, magistrate was under obligation to provide free legal aid to the accused. Second important thing is that this case is important because Supreme Court for the first time held that accused or suspect, they are entitled to have counsel right from the arrest and till the completion of the trial. This right, this precious right cannot only be availed at the time of trial, but right to free legal aid can also be availed at that very moment when a person is arrested by the police officer. So, from the time of arrest until the completion of trial, right to free legal aid must be provided to the poor accused. An accused person can refuse to give answer to the question asked by the investigating officer unless his counsel, unless he is provided a counsel advocate. So, accused or suspect has right to to have a counsel at the time of interrogation, at the time of inquiry, at the time of trial. So, you need to understand that as at these three various stages, at the time of interrogation, this is the first step, where soon after the arrest accused must be provided advocate counsel, so that police atrocity can be avoided or the possibility of police atrocity or custodial violence may be avoided. So, for that reason Supreme Court has emphasized that Supreme Court has issued various guidelines that soon after the arrest accused or suspect must be provided lawyer, advocate, and accused may demand, he can demand that his counsel should be present in that very room where interrogation is going on. So, accused can refuse to reply any question which is asked by the investigating officer unless his counsel appears in that very room, in that very at that very place where interrogation is going on. So, this kind of protection was given by Supreme Court to the accused, so that police atrocity or custodial violence can be avoided, can be prevented. So, for that purpose, so Khatri case is very important from that perspective. So, you all need to remember this case, and ultimately Supreme Court observed in this case that all the accused who had lost their eyesight must be awarded compensation by the government. State government concerned, Bihar government was directed by the Supreme Court to provide compensation to the victim of crime, and so that victim of crime can be rehabilitated. So, for rehabilitation purpose compensation was awarded, and it was also observed by Supreme Court that advocate must be provided to the suspect or accused right from the investigation till the completion of trial. Now, come to another aspect of fair trial. Fair trial also, a trial to become fair must be expeditiously tried by the court. So, trial court is obliged to try a case expeditiously. So, justice delayed is justice denied. If justice is delayed, that is denial of justice. So, right to speedy trial, that is also fundamental right guaranteed under Article 21 of the Indian Constitution. So, this right to speedy trial is not expressly provided in Article 21, but it is provided in that Article 21 impliedly. So, Supreme Court for the first time in M.H. Hoscott versus State of Bihar, AIR 1980 Supreme Court for the first time held that right to speedy trial is essential component of right to life or personal liberty. So, right, you see, this right to fair trial requires that trial must be conducted expeditiously, and where accused who has committed a crime which is punishable with imprisonment of 3 years, and that accused is languishing in jail for more than 3 years because his trial is not conducted by the trial court due to lack of evidence, due to any other technical reason, and accused is still languishing in jail for more than 3 years. If he would have been prosecuted and convicted by that trial court, so, and you see that accused who has committed such an offence which is punishable with 3 years imprisonment and is languishing in jail for more than 3 years, so it would be injustice on the part of government. So, in that situation, that accused must be released by the court if trial is still pending. So, you see the irony of law is Indian Parliament has inserted a specific provision in CRPC, Criminal Amendment Act, so that this kind of thing can be avoided. I will discuss that provision, but right to speedy trial, it is also essential component of fair trial, and I have already highlighted when this. Now, you just look at this, or this is my another slide where I have tried to transfer of criminal case to ensure fair trial. You see, trial court has to ensure fair justice. Justice must be impartial. Judges must be impartial. So, where objection is raised by accused that if case is decided by this judge may be biased. So, where this kind of objection is raised by an accused, it is the duty of higher court to transfer that criminal case from that court where objection is raised by the accused. For what? Just to provide impartial justice. It is quite possible that a judge may be a brother or sister of the victim of crime, and where judge is brother or sister or father of any relative, blood relative of victim of crime, it is quite possible that judge may be biased in favor of victim of crime. So, in that situation where application is made by accused to the court, that judge may be biased because victim of crime, complainant and judge both are relatives. So, in that situation, higher court, particularly High Court and Supreme Court has power to transfer that criminal case from one court to another court. Supreme Court has power to transfer any criminal case from one High Court to another High Court. High Court has power to transfer any criminal case from one district to another district. The purpose behind transferring criminal case from one High Court to another High Court is just to ensure fair trial and provide impartial justice. And ultimately, the purpose of transfer of criminal case is to maintain confidence of people in justice delivery system. So, this is the purpose behind transfer of criminal case from one state to another state, from one High Court to another High Court, from one district court to another district court. So, now let us see the statutory provision where these provisions are specifically provided. Section 40, you see section 406 is important. Supreme Court may transfer under section 406, Supreme Court may transfer any criminal case from one High Court to another High Court. And you all might be aware, I have already highlighted this case in my previous lecture, Madhumita Shukla murder case. Jahira, this is Jahira. Jahira Sheikh was state of Gujarat, Best Bakery. This case is popularly known as Best Bakery case. Section 404 talks about High Court has power to transfer criminal case from one session court to another session court. Now, let us see section 406 CRPC, which empowers the Supreme Court to transfer a case from one state to another state. As you all might be aware about Jahira Sheikh case, Jahira Sheikh was state of Gujarat, AIR 2004 Supreme Court. This case is popularly known as Best Bakery case. You see what happened in Jahira Sheikh case after Godhra incident. A ruling mob had looted and attacked on Best Bakery shop, which was being run by father of Jaira Sheikh. So that ruling mob killed father of Jaira Sheikh and two other laborers who were working in that Best Bakery. So when matter was reported when FIR was filed by Jaira Sheikh, trial was conducted. So trial court acquitted all the accused in the absence of evidence. The acquittal of accused got attracted electronic and print media highlighted that issue, that all the accused who were involved in Best Bakery case had been acquitted. So Supreme Court took cognizance suo motu in this case and transferred that case from Gujarat High Court to Maharashtra High Court. So case was transferred from Gujarat to Maharashtra High Court so that matter may be retried. And you will be surprised to know in that state Supreme Court ordered for retrial of the case. So wherever trial is not conducted fairly, you see, in case of fair trial, where trial court has failed to try a case in a fair manner, if trial is not just and reasonable, then Supreme Court or High Court, they have power to give direction to the subordinate court that matter should be retried. So Supreme Court in this case, Best Bakery case, Supreme Court ordered for retrial of the case. Madhumita Shukla murder case is also important case on this point, where now come to this another important aspect of fair trial. This is my another important slide where I have highlighted constitutional provision. So Constitution itself talks about fair trial, and for that reason Constitution has guaranteed three important rights under Article 20 Clause 1, 20 Clause 2, 20 Clause 3. Article 20 Clause 1 talks about protection against ex post facto law. Article 20 Clause 2 talks about protection against double jeopardy, and Article 20 Clause 3 talks about protection against self-incrimination. So I would like to discuss one by one. You see, Article 21, this is how this right, this fundamental right is connected with fair trial. Protection against ex post facto laws, no punishment without law. Article 20 Clause 1, it provides protection to an accused against his act, an act which was not an offence on the date of commission of the act cannot be considered as an offence by making a law. So Article 20 Clause 1, it protects ex post facto law, means the act which was done by an accused was not contrary to the law, was not an offence on the date of commission of the act. For that act, no person can be prosecuted and convicted. So Article 20 Clause 1, it has prohibited ex post facto law, that Parliament, neither Parliament nor state legislature can make ex post facto law, and by making ex post facto law, person cannot be penalized, cannot be convicted. This is a kind of protection and it is directly connected with fair trial. Trial would not be treated as fair trial where a person is tried by the trial court for that act which was not offence on the date of commission of the act. Article 21. Article 22, you see Article 22 talks about protection against double jeopardy. So, let us understand what is double jeopardy. As protection against double jeopardy, Latin maxim is nemo debet bis vexari. This is the Latin maxim, and the English meaning of this Latin maxim is no one can be vexed twice for the same offence. The concept of double jeopardy has been borrowed from USA. In US legal system, in American legal system, there is a concept that no person shall be punished for the same offence. No person shall be prosecuted and punished for more than once. So this concept is known as double jeopardy. No one can be vexed twice for the same offence. So the similar concept has been, the similar protection has been given in civil matter also. Section, if you have any idea about CPC, Civil Procedure Code, Section 11 of CPC talks about res judicata. A civil suit which has already been decided by a civil court cannot be reopened. A matter which has already been decided by a court, competent court, cannot be reopened by the same court between the same parties. It would be violation of res judicata. So this kind of, you see, protection is given under Article 20 Clause 2, protection against double jeopardy. So in order to take defense of double jeopardy, that person must establish before the court that he has already been prosecuted and convicted in any offence. Criminal court is going to prosecute and convict him in the same offence. Offence must be same, accused must be same, and competent authority must also be same. This protection against double jeopardy is not available against appeal. So appellate courts are free to prosecute and convict for the same offence and to the same accused. So this principle is not available against appellate court. You all must understand this. So this is protection against double jeopardy. How double jeopardy and ex post facto law, these two things are directly connected with fair trial. Now come to statutory provision regarding fair trial. You just can see this. Section 327 CRPC. Section 327 CRPC talks about that trial court must be open court. For what? To ensure fair trial and maintain confidence in justice delivery system. This is the purpose of open court. Second important thing is that Section 273, recording of his statement in the presence of accused, CRPC. So I have covered these two important statutory provisions just to explain you the concept of fair trial with the help of these two important provisions, 327 CRPC and 273 CRPC. Section 327 CRPC talks about open court. Criminal court must be open court. What does it mean? Open court here means the trial must be conducted in open court, except few exceptions. Except in case of rape, in case of sexual offence, in case of matrimonial offence, matrimonial offences, sexual offences, cases pertaining to rape, this type of criminal case can only be conducted in closed in camera proceeding, in a closed court, in a closed room, third party is not allowed. So, that is why criminal courts are considered as open court. So, that third party, any stranger can enter into the premises, anyone can access to the justice, anyone can enter in the premises of criminal court, so that they can understand, they can see the court proceeding, how argument is going on, how that criminal case is decided. So, just to maintain, just to repose public confidence in justice delivery system, criminal courts are considered as open court. So, this is the purpose behind putting criminal court as a open court. So, section 327 CRPC talks about open court, criminal court must be open court. So, this is also connected with fair trial. Otherwise, people may have apprehension that what is going on in a closed room, what is going on in a closed court. So, people may have people may have suspicion, people may have doubt about justice delivery system. So, for that purpose, section 327 provides that criminal case must be decided in open court, so that a stranger, any person who is willing to see the court proceeding may be allowed to appear in the court and must be allowed to see the judicial proceeding. So, this is about open court, section 327 CRPC, and 273 CRPC is also important. This section 273 is directly connected with principle of natural justice, RD alteram partem, rule of fair hearing. Section 273 CRPC says that the statement of the accused must be recorded by criminal court in his presence. No criminal court can record the statement of accused in his absence. It would be injustice, it would be violation of principle of natural justice. So, all the criminal courts are bound to record the statement of accused in their presence, so that accused can represent himself before the court, so that accused can provide sufficient evidences in the court of law, and court can consider the goodness or badness of that matter. So, recording of statement in the presence of accused, that is essential component of fair trial. The exception of this rule is section 299 in the same code CRPC. So, section 273 and 299 these two provisions are read together. Section 299 CRPC says that the statement of accused may also be recorded in the absence of accused. For example, where Daud Ibrahim, who was involved in Bombay bomb blast, he was identified, his guilty partners Tiger Menon, Yaqub Menon, his guilty partners, they were identified by the witnesses, by the investigating agencies. So, in the absence of Daud Ibrahim, trial court was empowered to record the statement of his guilty partners. He was co-accused, accomplice, associated with that case. So, in the exception, and whenever he would be extradited in this country, he would appear, he would be brought before the court. Trial court will prosecute and convict him because he is identified. So, a recording of his statement in the absence of accused is permitted by section 299 of the CRPC. So, this is the purpose behind empowering the criminal court to record a statement of accused in their presence, is to give opportunity to the accused, so that he can take defense before the authority, before the court, whether he is guilty or innocent. If a statement would be recorded in the presence of the accused, he can take defense, he can prove his innocence or he may be innocent or he may be guilty. So, this is the purpose behind recording statement in the presence of the accused, section 273. So, you see I have covered each and every aspect of fair trial, right from UDHR article 10 and 11, Indian Constitution article 22, case judicial view, role of Supreme Court in recognizing right to fair trial as a fundamental right is essential component of article 21 of the Indian Constitution. This right to fair trial is essential component of right to life and personal liberty. So, for that purpose Supreme Court has evolved two important case law, where in Hussain Ara Khatun versus State of Bihar, Supreme Court said that speedy trial is fundamental right. MH House Court, Supreme Court held that right to free legal aid is a fundamental right. Khatri versus State of Bihar, Supreme Court held that accused, they are entitled to consult from their advocate right from the interrogation till the completion of trial. If they are not provided counsel at the time of arrest or at the time of trial, that trial cannot be treated as fair trial. So, you will have to consider all these relevant case laws for fair trial, and I do believe that if you have understood this lecture, you can crack all the examinations in which you are going to appear. This would be very helpful for you. So, with this I would like to conclude this lecture. Thank you all.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.